Good morning and good afternoon to all our attendees and panelists. I hope you're all staying safe and well. Thank you for attending our webinar today. My name is Minh.Luong. I'm a partner with Chugh LLP. We are a full-service law and accounting firm with 6 offices in the United States, 7 in India, and our Chugh global affiliates in several other countries. Our focus is that we provide outside general counsel services for businesses in the fields of corporate law, litigation, immigration, and tax and accounting services. As certain areas of the country have been reopening in waves, the market's up today, and with the hopes of an increase in consumer spending, it's important to know how the guidelines apply to the reopening of your office. Today we have a wonderful group of attorneys based throughout the country that will focus on federal and their state-specific guidelines. So we all know that due to the pandemic, the laws and guidelines are constantly changing. So please confirm which sources your business is reviewing and when they were posted to assure that you have the most up-to-date information. At the end of the day, we're here to support you to return to work safely, remain in compliance, and of course, avoid lawsuits as best as possible. We have a Q&A feature on the chat box there on Teams. So feel free to chat your questions and we'll have a Q&A session at the end of the presentation as well. To start our discussion on the updated CDC guidelines, we have Varduhi Danielian, an attorney from our LA office. Varduhi?
Thank you, Jamin. Hello, everyone. I hope you all are well and safe during these trying times. So let's talk about the recommendations that CDC has come up with. CDC, the Center for Disease Control and Prevention, is a federal agency, and it has issued certain recommendations for the public as well as for employers. Its main goal, as you can imagine, is to protect public health and safety through the control and prevention of disease. So if we jump straight into recommendations, employers are recommended to develop an infectious disease preparedness and response plan, as well as a sanitation plan. Before developing such plans, it is recommended to double-check any federal and state laws, as well as local ordinances. The response plan should consider where and how might employees be exposed to general public, customers and co-workers, and sick individuals. Employers should remind of social distancing. Social distancing, also called physical distancing, a term we keep hearing every day, it means keeping space between yourself and other people outside of your home. To practice social distancing, people are advised to stay at least 6 feet from other people, and that's about 2 arms length, and then not gathering groups and stay out of crowded places. Employers should limit employees' close contact with others in indoor and outdoor spaces. Spread of COVID-19 happens when an infected person coughs, sneezes, or talks, and droplets can be inhaled by people nearby. Therefore, employers should set certain restrictions on employees grouping in lunchrooms, copy rooms, conference rooms, any other common areas where employees tend to group. Employers should also recommend employees to avoid any group lunches outside the building. Employers should develop workplace flexibilities to reduce in-person meetings and shift to telework where possible, to establish alternating shifts, to discontinue any non-essential travel. Each employee should wear masks, clean and disinfect after themselves when they use frequently used surfaces, such as countertops, printers. Employees should be encouraged to frequently wash their hands with soap and use sanitizers. Employers should have more rigorous requirements for cleaners. Such people should wear disposable gloves at all times to clean and disinfect the premises. They should also have disposable gowns. Employers should provide training to cleaning staff prior to providing cleaning tasks. So in practical terms, what this means is that employers first need to obtain all of these disinfectants, disposable masks, disposable gloves, so employees can use them. The government has compiled a list of disinfectant products that can be used against COVID-19, including sprays, concentrates, and wipes. It is important to remember that there are different disinfectants for different surfaces. And as for sanitizers, these are effective if they have at least 60% alcohol in it. So now let's talk about the sanitation plan. The sanitation plan shall include basic infection prevention measures. Employers should evaluate the workplace to determine what kinds of surfaces and materials make up the area. Surfaces need to be cleaned with soap and water first, and then only with a disinfectant. Using only a disinfectant does not suffice. More frequently used surfaces, such as in the restrooms, lunchrooms, or other common areas, shall be cleaned regularly. Employers should have routine cleaning practices in place. High-touch surfaces such as tables, doorknobs, countertops, handles, faucets, toilets shall be cleaned regularly. You should also consider what items can be moved or removed completely to reduce frequent handling or contact from multiple people. Soft and porous materials such as area rugs and seating may be removed or stored to reduce the challenges with cleaning and disinfecting them. You could also consider leaving some doors open to reduce touching by multiple people, opening windows to improve ventilation, or removing objects in your common area, like coffee creamer containers. So now let's assume you have an infected employee. What should you do? First of all, a prompt identification and isolation of potentially infectious individual is a critical step in protecting workers, customers, visitors, and others at the worksite. Employers should inform and encourage employees to self-monitor for signs and symptoms of COVID-19 if they suspect possible exposure. Employers should develop policies and procedures for employees to report when they are sick or experiencing symptoms of COVID-19. For example, they can have questionnaires in place and require employees to fill out the questionnaires at least once a day. In terms of sanitation, first you should close off areas used by the person who is sick. Open outside doors and windows to increase air circulation in the area. If possible, wait 24 hours before you clean or disinfect. Clean and disinfect all areas used by the person who is sick, such as offices, bathrooms, common areas, shared electronic equipment. If you decided to vacuum the space, turn off the fans in the building, so that the particles that escape from vacuuming will not circulate throughout the facility. Moving on to the temperature checks. Generally, measuring an employee's body temperature is a medical examination. What that means is that under the ADA, Americans with Disability Act, taking an employee's temperature generally would be impermissible unless it was job-related and consistent with business necessity. However, because the CDC and state local health authorities have acknowledged community spread of COVID-19 and issued attendant precautions, employers may measure employees' body temperature. The person doing the temperature checks should be trained and should use touchless forehead or other outside of the body thermometer methods. Because of privacy rights and HIPAA regulations, collected information should be treated as confidential and shared only with those who have a need to know. So employers must maintain all information about an employee's illness as a confidential medical record in compliance with the ADA. That should be separate from the employee's personnel file. An employer may, however, disclose the name of an employee to a public health agency upon learning that the employee has COVID-19. It is critical for employers to understand that this is temporary and may discontinue once the pandemic unfolds. In California, if a business is covered by California Consumer Protection Act, the business needs to provide a notice to an employee before checking the temperature. As for HIPAA, HIPAA privacy rule allows a covered entity such as healthcare providers to share the name or other identifying information of an individual who has been infected with or exposed to COVID-19 with law enforcement, paramedics, other first responders, and public health authorities without an individual's authorization. I hope this was helpful. Back to you, Jamin.
Thank you, Varduri. That was very helpful. Thank you.
Thank you.
To talk some about the masks and PPE, we've got Vikram.Subramanian, an attorney from our Santa Clara office.
Thank you, Jamin. So to begin with, for all the employers out there, during this pandemic, we strongly advise you provide your employees with masks and other safety equipment necessary to complete their job duties. And a lot of this is a result of your local shelter-in-place orders as well. In addition, for example, with respect to California, California Labor Code Section 2802 obligates employers to reimburse employees for quote unquote all necessary expenditures incurred by the employee while completing his or her work duties. I strongly suspect there's similar statutes in states all across the US. So, the reimbursement is probably going to apply to a lot of employers out there. Now, the CDC advises using simple cloth face coverings to help stop the spread, and to especially help stop the spread of the people who may have the virus and who don't know it, the asymptomatic people, if you will. Now, cloth face coverings can be made from simple household items. And the reason why household items are recommended is a lot of people out there are trying to get surgical masks and getting N95 respirators. Those are only to be reserved for healthcare workers and medical first responders. So it's highly looked down upon for everyday people like you and me, accountants, lawyers, if you will, wearing computer programmers wearing cloth masks. It's strictly reserved for people in the medical profession. And again, these are strongly recommended in places where it's hard to enforce social distancing. Obviously grocery stores, gas stations, but what's relevant here is definitely in places of employment as well. And what it does is it really helps slow the spread, because if you don't know if you have it, you can't isolate at home. So the best thing to do is everyone should wear a mask in public settings. Now, to wear it correctly, of course, definitely always wash your hands first before putting on the covering. Make sure it covers your nose and mouth. Make sure you can breathe easily. I know a lot of us, we've had experiences putting on the masks and it kind of inhibits our breathing. And if you're asthmatic, if you have other illnesses, breathing problems, you want to make sure you have a very breathable mask. But definitely keep those portions of your face covered the entire time you're in public, specifically being the nose and the mouth. And don't touch the face covering. And if you do, you need to wash your hands as soon as possible. That's why it's always good to carry your own hand sanitizer, because you're not always going to have a wash basin and hand soap in front of you. When you take it off, be very careful. Don't touch your eyes, nose, and mouth, and immediately wash your hands after removing the mask. And most importantly, the cloth face covering should be washed every day, and with disinfecting bleach, no less, for at least 5 minutes after use. Be allowed to fully dry before you can use it again. And thank you for your time today. Back to you, Jamin.
Thank you, Vikram. I know, as you mentioned, the mask, the proper wear of the masks, it gets really hot, and our healthcare workers and everyone, a big shout out to them, and thank you for all that you do and being behind the masks and on the front lines. Next, we've got Nishita Patel to discuss the Occupational Safety and Health Administration, better known as OSHA, which assures that the employers are creating a safe work environment for their employees. Nishita, please go ahead.
Thanks, Jamie. Hello, everybody. I'm going to talk about OSHA's standard requirements, record keeping, and reporting guidance as it relates to COVID-19. As we all know, OSHA is a federal agency which aims to ensure employers provide a safe work environment to their employees. OSHA offers a great deal of information to assist employers in complying with their responsibilities under OSHA laws and preventing workplace hazard in form of assistance, service and programs, recommendations, and educational materials on its website. OSHA has also released a general and industry-specific guidance with recommendations for protecting employees during COVID pandemic. While OSHA's guidance is advisory and not mandatory, it provides useful tools to employees seeking to protect employees under pandemic. To that end, OSHA's recommendations features administrative controls, hygiene measures, face covering, and social distancing. These recommendations are similar to CDC recommendations and have already been covered by my colleagues Varduhi and Vikram. OSHA standard requirements relating to COVID-19. OSHA requires the employers need to implement a PPE program to address the hazard present, the selection and maintenance of the use of PPE, training of the employees, and monitoring the programs to ensure the ongoing effectiveness. Employers are required to provide protective equipment in terms of gloves, eye and face protection to their workers and ensure its proper use. Next, the employers are required to furnish each employee a place of employment which is free from any hazard that is likely to cause death or serious physical harm. Next, the employers are also required to comply with standards relating to sanitation and communications of risk relating to hazardous chemicals that may be in the common sanitizers and sterilizers. Next, OSHA also requires the employers to keep records of all work-related fatalities, injuries, and illness that meet certain recording criteria. Per OSHA's record-keeping requirements, COVID-19 is a recordable illness, and thus the employers are responsible to record cases of COVID-19 if, number one, the case is a confirmed case of COVID-19, the case is work-related, and the case involves one or more of the general recording criteria, which includes medical treatment beyond first aid, restricted work, days away from work. In view of the quarantine requirements of COVID-19, one of the three requirements with most of the time will be met. Now, what is work-relatedness inquiry? The employer is responsible to determine the work-relatedness is based on the circumstantial information. It remains difficult to determine whether a COVID-19 illness is work-related, specifically when an employer has experienced potential exposure both in and out of the workspace. As a result, the OSHA focuses on the employer's reasonable and good faith effort in making work-related determination. So, for example, there is an infected employee. As long as the employer makes a reasonable and good faith inquiry, but cannot determine whether more likely than not the exposure was in the workplace caused a worker to contact COVID-19, the employer does not have to record the case. The next requirement is the reporting requirement. OSHA's severe injury guidelines require all employers to directly notify OSHA, either by phone or online, whether an employee suffers a work-related fatality, amputation, loss of an eye, or inpatient hospitalization. In case of a fatality, the employer need to notify the OSHA within 8 hours of the incident. In case of an inpatient hospitalization, amputation, or loss of an eye, employer need to notify the OSHA within 24 hours of the incident. Now, what is inpatient hospitalization? Inpatient hospitalization is defined as formal admission to the inpatient service of a hospital or a clinic for care or treatment. Treatment in an emergency room or an outpatient hospital is not reportable. Now, for example, if an employee has a confirmed case of COVID-19 that is considered work-related, then employer need to report the case to OSHA if it results in fatality or inpatient hospitalization. However, since the reporting requirement is time limited, if the fatality due to COVID-19 occurs after 30 days of the workplace incident leading to the illness, an employer is not required to report it. Similarly, if the employee has confirmed case of COVID-19 that is work-related, however, the inpatient hospitalization occurred after 24 hours from the workplace incident leading to the illness, the employer is not required to report to OSHA. For example, if an employee contracts COVID-19 on a business trip outside of the United States, it is not a recordable case since the exposure occurred outside of the jurisdiction of the United States. Now, in case of the employers with 10 or fewer employees, they are not required to comply with the recording obligations under OSHA, but they are required to report a COVID-19 case if there is a fatality or inpatient hospitalization. Lastly, in addition to the requirements of and recommendations that like from OSHA and CDC, the employers may be required to comply with the state and local city, county requirements for occupational safety and health programs. It is important to note that several states and local emergency orders have authorized stringent requirements and recommendations than those of OSHA and CDC. Thank you. Back to you, Jamin.
Thank you, Nishita. That was very helpful. Next, we've got the topic of workplace health and safety guidance, and our senior attorney, Brinda Gandhi from our LA office will cover that.
Thank you, Jamin. Hi, everyone. Nishita just covered the federal guidelines. I'm going to talk a little about the California workplace health and safety guidelines. So I'm sure a lot of you have already started your businesses and some of you have not. So for those of you who have not, you must ensure before you open your business that you perform a detailed risk assessment and create a site-specific protection plan. You have to train your employees on how to limit the spread of COVID-19, as Vardhu and Vikram already discussed earlier, put disinfection protocols in place, and establish physical distancing guidelines. It's important that employees with COVID-19 know that they should stay at home, and your sick leave policies will need to support that. We've provided links to California industry and county-specific guidance, but if any of you need help with drafting a specific back-to-work policy to circulate to all your employees, feel free to reach out to one of the attorneys here. With that being said, back to you, Jamin.
Thank you, Brinda, and thanks for that. We will put everyone's contact information up at the end as well. So next we've got two attorneys that are going to cover the FFCRA and the EFMLA, which are enacted from the CARES Act. And so we've got Hooman.Yavi from our Santa Clara office and Minh.Luong from our Los Angeles office.
Thank you, Jamin. So as Jamin mentioned early on in the presentation, part of going back to work involves, avoiding lawsuits. And what we want to do is make sure that as you do return back to work, that you continue to be in compliance with the new regulations with respect to sick leave and family emergency leave. So there is some anticipation that cases will continue to grow, and as they grow and your employees are coming back to work, you're going to want to follow the FFCRA, which has been in place for the last few months. Again, the FFCRA provides both a sick leave policy, and it also extends the FMLA to certain topics as well. So in terms of FFCRA and the sick leave rules, so this applies to any company with fewer than 500 employees. And if your employee is subject to a federal, state, or local quarantine or isolation order, if your employee is advised by a doctor to self-quarantine, or if your employee is experiencing symptoms, they have a right to take off up to 80 hours if they're full-time, and the average of 2 weeks if they're part-time. And that's all PTO, so they can take that time off paid, and you would have to pay them at their regular wage, and that's going to be capped at $511 a day or $5,110 total. I'm just going to go into a few details about paid sick leave. So the FFCRA paid sick leave provisions apply only to part-time workers as well as full-time employees, but they don't apply to independent contractors. You also can't require your employees to use their PTO, or you can't require them to use other paid time off when they specifically need the time off for COVID-related issues. And also, when Nishita and the other attorneys went over the OSHA issues, if you have an employee taking time off for workman's comp issues, they can't take FFCRA sick leave if they're already on workman's comp. There's also not a significant notice requirement on the employee side, and you actually can't require them to provide you with too much information. So all they have to do is tell you that they have symptoms, or that they visited a doctor and the date of the doctor visit, and you really can't dig too deep because that might violate HIPAA. On the flip side, on the employer side, there is a dollar-for-dollar tax credit, and the IRS will reimburse the employers for qualifying wages. Now, if you're using PPP funds to pay the FFCRA wages, you may not be able to have the PPP fund used for FFCRA wages forgiven, or you may not be able to get that tax credit, the dollar-for-dollar reimbursement. So there's also a few specific rules that were enacted by cities in the Bay Area, particularly, and in some other locations. Particularly San Jose, San Francisco, and Oakland have passed local ordinances that extend FFCRA to companies that have more than 500 employees. So again, FFCRA was companies less than 500, but these cities went ahead and they provided the stopgap measure. San Jose also covers employers with 50 or fewer workers as well. Oakland has a special provision that requires employers to cash out the employees for non-emergency sick leave prior to layoff. So if you have employees who are accruing sick leave and then you go through a phase of layoff, you have to encash them for the accrued sick leave. So I'm going to pass the ball to Min, who's going to go over the FMLA and how it's being extended by FFCRA. So Minh.Luong.
Thank you, Hooman, and thank you everyone for being here today. I am going to discuss the FMLA and California paid family leave and then other California specific laws. Under FMLA, employees can take up to 12 weeks of unpaid leave. The employee's job is protected during this time, and it could be seen as retaliation or wrongful termination if you terminate employment because employee exercised this right. In the past, there was no federal law that requires companies to provide paid leave to employees who needed time off to take care of their family members. Then on March, due to COVID and the health pandemic, there's this new emergency FMLA. This provides paid leave for employees who can't work or telework because he or she has to care for their child due to COVID-related reason. It's very specific to their children, and it could include they have to care for the child because the school has been closed due to COVID. Under the emergency FMLA, the first 10 days is unpaid, but after that, the employees would get paid 2/3 of their pay rate for a maximum of $200 per day for a maximum of $10,000 total. There are 8 states with their own paid family leave, and California is one of them. In California, employees can take 6 weeks of paid family leave to care for a seriously ill family member. The 6 weeks will increase to 8 weeks starting next month, July 1st. And seriously ill family member is more broad than the emergency FMLA. It includes parents, grandparents, siblings, and so on. So the employee can receive between 60 to 70% of their weekly salary. The next slide deals with unemployment insurance. The benefit an employee gets when they're not able to work through no fault of their own is unemployment insurance. And as we go back to work, companies are trying to rehire employees who were receiving unemployment benefits. So in California, unemployment insurance ranged from $40 to $450. As many of us know, the federal government has been providing an additional $600 per week. This is set to end July 31st. There are discussions that it may get extended, but as of today, it's not official yet. Many of our clients are asking us if their PPP loan forgiveness will be reduced if the employee doesn't want to go back to work, since they're essentially receiving the same amount from unemployment. The answer is no. SBA had released guidelines indicating that the loan forgiveness amount will not be reduced so long as you document the offer of employment and the employee reject the offer. So it's really important to keep these documentation. The next slide deals with disability insurance. Disability insurance provides partial wage benefit to workers who can't work because of a non-work related injury, and it's funded through state disability insurance. Employers have a duty to provide information and post information at the workplace. So as people are going back to work, it's important that we update these information and post it at a place where everyone could see it. We've provided a link where you can get some sample of notices. Workers' compensation is for employees who, the next slide deals with workers' compensation for employees who gets injured due to work-related reason. So in California, Governor Newsom signed an executive order. There is a rebuttable presumption that employees who worked and caught COVID-19, it arose out of the course of employment if they can prove that they tested positive and the test was done by a physician licensed with the California Medical Board. They caught COVID-19 within 14 days after performing work at the place of employment. The injury happened between March 19th and July 5th, and it doesn't count if the employee worked from home. So it's really important as people go back to work to avoid workers' comp claims that we have documentations of all the steps we've taken, complying with Osha and everything else, so that as people go back to work and there are claims, employees have 30 days to rebut this presumption that COVID-19 arose out of employment. Back to you, Jamin.
Thank you so much, Min. So we've been discussing a lot about federal law in California, and so as I mentioned, we've got several other offices in the United States. One of our senior attorneys, Prema Radham, she's an attorney who works out of both our New Jersey office and the Manhattan office. So she's going to discuss some of the New York and New Jersey ordinances.
Thank you, Jamin. Hello, everyone. In addition to all the important information of the federal laws like CDC and Osha, which are applicable for all states and requirements that my colleagues have discussed earlier, states can have other laws and requirements that employers should be aware of. It's very important to have a safety plan and back to work policies for each office. New Jersey recommends businesses and companies opening up offices to have a maximum capacity of 50% and to take all necessary precautions and provide the necessary PPEs and a safety plan clearly visible to all their employees. Back to work has several other angles that employers need to plan for. In addition to the Federal Paid Sick Leave Act, New Jersey has modified the New Jersey Paid Sick Leave Act and the Family Leave Act so that they can use their unexhausted sick leave in addition to the federal leave available for their own COVID illnesses, or if they need to take care of a family member, or if an employee's child's school is closed, they can use this as well. In New Jersey, there's also a duty of an employer to notify the New Jersey Division of Unemployment if an employee refuses reinstatement after a furlough. So some of you may be facing this situation. The New Jersey Division of Unemployment Insurance requires an employer to immediately notify the division within 48 hours of an employee's failure to return to work after an offer of employment is made for the employee to return to work. They can do that by completing a form, and they need to provide information as to the date the position was offered, the reason for the employee's refusal, and the details about the specific position. They also have this obligation to report this information on a quarterly basis. So employers also have a choice to recall furloughed employees, right? But they cannot discriminate on basis of COVID-19. So there is the New Jersey law against discrimination that includes COVID-19 related discrimination that is prohibited. And the other thing to remember is the New Jersey also, the WARN Act applies to New Jersey. It requires that employers provide its employees with 60 days notice prior to its termination for any companies that have 100 or more full-time employees. Now, moving on to New York, as many of you may be aware, there has been an executive, or there's several executive orders. New York is one of the most affected states in our country, but the state is on pause, and businesses that can rely only on in-office personnel were decreased to 100%. So New York is officially opening today for non-essential businesses. However, under certain strict guidelines with 12 categories that are listed out. So if your business or company is not listed here, you can make an application to the state to be included within those 12 categories so that you can have some kind of an opening. As you all may be aware, New York has unique issues to deal with related to opening of offices, particularly with employees traveling, taking public transportation, with the close proximity with others, and then just the sheer population in New York. To the extent possible, if an employee can work from home, then the risk of contracting COVID-19 for work-related reasons can be avoided. If an employer requires an employee to come to the office, then considerations need to be made regarding safety of the employee during transit and if it's really worth the risk. The New York Sick Leave Act applies to all employers with any number of employees in New York. An employee is eligible for paid time off if they present to their employer a mandatory or precautionary order or quarantine or isolation. The Health Department of New York has issued guidelines to confirm that only those employees who have been exposed to COVID-19 in some fashion or travel to high-risk area will be allowed leave under this law. There are certain specific termination requirements that one should know in New York. If an employer decides to permanently lay off or terminate an employee, it has certain obligations that the pay must be made within the next regular payday. The employer must provide employee with an unemployment insurance notice, and the employer must notify the employee within 5 days of the termination date of the exact date of termination, as well as the date of cancellation of the benefits. New York also follows, the WARN Act is also applicable to New York. And they also, in New York, I must specify that New York has the Department of Consumer and Worker Protection has published updated guidelines for hourly employees. So under this law, New York employees can ask to make temporary changes to their own schedules for certain personal events for up to 2 days. So these are certain of the New York and New Jersey requirements that are applicable under these circumstances. Back to you, Jamin.
Thank you so much, Prema. I'll cover Georgia in very briefly. So Governor Kemp issued the executive order on April the 30th, which expires at the end of this week on Friday. And I'll cover some of the more pressing businesses or types of businesses. So medical offices were to open as soon as practicable. The in-person critical infrastructure businesses, such as law firms, banks, their financial services, They had to take the temperatures of the employees coming in, as Verdu he had mentioned, pursuant to the CDC guidelines, and prohibit those employees that have a temperature of 100.4 or higher from coming into the office, prohibit gatherings at the office, create staggered shifts so that there aren't too many employees at the office, encourage or mandate teleworking, prohibit handshaking and discourage the use of others or common workstations, and where applicable, suspend the use of PIN pads or electronic signatures. For restaurants, the big one was that the restaurants were told that they could only have 10 patrons per 500 square feet, and grocery stores had to create early hours for vulnerable populations such as immunocompromised and the elderly, and reduce hours for increased cleaning and sanitation on a daily basis, install plexiglass to protect the employees, close all self-service bars and buffets. And finally, childcare facilities for those that have kids, and part of the FFCRA and the Fmla was to assist those parents who couldn't send their kids to school or daycare facilities. So what they're doing in Georgia is that they're limiting parents from coming in and other family members. The kids that have a temperature of 100.4 that exhibit cough or shortness of breath symptoms are prevented from coming into the school that day. They're saying that they have to wash and sanitize all the toys as soon as one kid touches it or puts it, in their mouth or whatever the case is. They're trying to prevent all of those things. That's going to be pretty difficult, but I think they're doing the best they can. Some of the daycare facilities and schools are opening back up this week. But I'd like to open it up for a Q&A session. I see that there are some already there. We'll start from the top. What is the recommended frequency for cleaning? Does that depend on the number of people in the facility? Verdui, could you please handle that one?
Sure, thank you, Jamin. So CDC does not have a certain type of recommendation as to how many times the facilities need to be cleaned. It depends on the type of business, I think. If you have many customers, many employees on the premises, it is recommended to do it multiple times a day. And then if not many people, if it's a small office space and not many people come to the office, maybe like twice or 3 times a day would suffice. So it's typically the CDC leaves it to the employers to decide. And then also, as I mentioned in the presentation, it depends which areas you want to clean multiple times. Like there are areas that are common areas and are used a few times a day. These areas need to be cleaned regularly. And there can be areas in the facility that maybe employees use it like once or twice a day. Then maybe you could clean it only once a day, and that would suffice. So it's typically up to an employer that is why the CDC is saying employers should go through their facility, see what items they have on the facility, remove some of the items that they do not use frequently, keep the items that they use frequently, and decide how they are going to clean, how many times during the day they are going to clean, and which disinfectants and materials they are going to use to clean the premises.
Great, thank you. And Verdui, while I have you, there's one more here.
Sure.
The attendee asked that they heard that they could only take the temperature. Sorry, let me show you here. Are they supposed to record the actual temperature due to HIPAA regulations, or should they not?
So they should record the temperature once they checked it. However, they cannot pronounce it. So like, let's say you have many employees in that space and then you are checking employees' temperature one after another. You see that one employee's temperature, let's say, is higher than the required, than the maximum you could have according to your local ordinances, let's say, or your state laws. Then you of course should record it. However, you cannot say out loud, so so that our employees do not hear that that employee has temperature. So you should have some kind of a procedure in place where another employee would just accompany that employee to some private area and then tell them what's their temperature, and that they have temperature, they are sick, they should leave the premises, and what leave they can take during that period of time. But you can record the temperature for sure. That's not going to violate the HIPAA rule. That's not going to violate the privacy rules of at least California. But I cannot talk about other states. So it's always recommended to check your state laws and local ordinances as well.
Right. Perfect. Thank you, Verdui. Really appreciate it. And to Prema, I guess commuting from New York, New Jersey, back and forth, there's millions of people that do that. One of the questions here, what if the employee has to travel in public transportation and he gets COVID due to that? Is the company still responsible, or is it work related?
Well, I think that he's saying the same thing, right? Whether it's work related or covered under the laws. But yes, if he's taking public transportation to get to work, and that the company, his employer requires him to be in the office, then it could be deemed work related. So that is something that he will need to discuss, the possibility of exposure in certain areas like New York that is heightened. So decisions need to be made with discussing with the employer whether it's really required or not.
And this is Vikram.Subramanian. To chime in, I think alternatively, maybe depending on the circumstance, maybe a claim would be pursued against public transportation authorities. So, having lived in New York and New Jersey myself, I know there's New Jersey Transit, there's MTA. I mean, maybe the public transit could be potentially liable as well.
All right.
Absolutely. All those laws and requirements and conditions are still being evolved as we speak, since they're not open yet completely. So this will be something interesting to watch, what kind of provisions are being made by the public transportation authorities.
Yeah, absolutely. It's evolving on a regular basis. So yeah, absolutely right. Thank you, Prema.
Thank you.
All right, Hooman, if you could take the next one, please. If an employee is not willing to come to the office, which leave option can they use other than PTO? Can they take EFMLA?
Sure. So the question first has to answer the question, we take a look at where the employee is, right? So if the employee is in California, let's take a look at California rules. Let's see where we are. Right now, we're in stage 2 of, so if you look at the California roadmap that is published by the governor's office, we're in stage 2. And so what stage 2 allows a lot of low risk workplaces to open. So that would be, logistics, manufacturing, offices, workplaces, outdoor museums, they have listed here. So if the employee is supposed to go back to work to one of these low risk places that can now open, then the employee can't claim that they're subject to a shelter in place order. So I think it becomes harder for the employee to say, hey, I want to take FFCRA sick leave if they're not subject to a current shelter in place order. But alternatively, if there's like a local ordinance, let's say you're I actually am not too familiar with every county, but in San Mateo County, they are essentially mirroring the California rules. So again, if you're working at like an office in San Mateo County or even Santa Clara County, and you need to, and your office says, hey, you need to come back to work, and the employee decides they don't want to come back to work, they need to be able to justify that somehow. So if they can't justify it under FFCRA, then the employee can turn now to other issues. So let's say it's not FMLA either. It's not the fact that they're taking care of, a child, they're not taking care of a sick person at home. And by the way, your kid's inability to go to summer school is not qualifying under FMLA or under EFMLA. So if your kid's summer school is closed and you have to stay home, take care of the kid, unfortunately, EFMLA does not cover you there. So let's say the employee can't do FFCRA, can't do EFMLA, then they would look at things like workplace safety. So if there's a reasonable and legitimate fear that there's something wrong at the workplace, then that employee could stay at home and say, hey, look, under Osha, I don't think that the workplace is safe. 10 people in our office of 100 people have gotten COVID. So, that ratio being extremely high, I don't think it's safe for me to go back to the workplace. See, that's a legitimate reason for them to stay at home, and then they would be able to do so. Now, if they're unable to do so even at that point, company has to decide whether they allow the employee to take PTO or not. Most companies don't like letting their employees take PTO for these reasons, because eventually, you're going to have to be very short-staffed, and their PTO is going to run out. It's not indefinite. So you may want to consider whether you approve these PTO requests or not. And if you're really unsure, just reach out to one of the folks on this panel, and we can go over it with you, come up with a strategy for how to respond to these requests from employees.
Great, thanks a lot, Hooman. And while I have you, are there any recent notifications or guidelines from the state of California to reopen the offices?
Yeah, so like I mentioned before, the state of California has this resilience roadmap, and it's a 4-stage roadmap that they've set up. Right now we're in stage 2. So stage 1 was what we experienced last few months, which was the very restrictive shelter-in-place orders. And now we're in stage 2, where they're allowing some businesses to reopen, but they have to make modifications that have been discussed throughout this entire discussion. And then hopefully, if stage 2 goes well, we'll start to see slightly higher risk workplaces be open in stage 3. And then ultimately, the goal is to reach stage 4, which is the end of the stay-at-home orders. All this information can be found on the California governor's website. I think it's covid19.ca or something. You also want to take a look at the county and city ordinances at all times too, especially, if you're in Santa Clara County, a lot of tech companies are trying to figure out how to bring people back to the office, or whether they really want to or not. So if you want a detailed analysis of county-wide ordinances, just feel free to reach out to us.
Great, thanks so much, Hooman. Vikram, if you could take the next one, please. The question from Lorraine Bravo. In an office setting, are we required to provide eye protection in addition to masks and gloves?
Thank you for your very intelligent question, Lorraine. And to answer it, I think, it'd be highly irresponsible of an employer to not provide the necessary equipment to keep its employees safe, especially if the employee is asking for it. Definitely you want to provide it, but it's just better to be proactive. I mean, I know a lot of employers out there, they may be concerned about the expense of providing all this gear. Well, I would consider the expense of not providing this gear, which could be a whole slew of workers' compensation lawsuits, and and that will end up be much more expensive. Even if you have workers' compensation insurance, the claims, your premium will go up. So I think you have to wait like that the cost of providing this equipment in the long run is going to be much less than the cost of just, letting the employees walk around without this equipment. And again, I would like to revert back to my citation of the California Labor Code, and also I'm sure many other states' labor codes that provides that employers are required to reimburse their employees for all necessary expenditures while completing work duties. And I don't think, I'm pretty sure most judges would agree that if an employee is concerned about the spread of COVID, if he or she wants reimbursement for eye protective wear, a judge would likely grant it because it can spread that way. So long story short, I think, again, there are some costs here. Again, I know one of our presenters mentioned that, hey, you can have your employees work remotely. That's the way of saving costs on buying this equipment. But like I said, long story short, I mean, you're better off incurring those costs for this protective equipment now than having to deal with a whole bunch of workers' compensation lawsuits down the road. Thank you.
Thanks so much, Vikram. Nishita, if this is a California-specific question, if an employee has symptoms of COVID or a confirmed case of COVID, can the employer require a negative test before that employee is allowed to return to the office?
Sure. As we discussed before, employers are required to ensure that that they provide a safe work environment for their employees, and in compliance with that, yes, the employer can require the employee to provide a negative test before the employee is allowed to return back to the office.
Okay, great. And one more here for Min. If an employee desires to work from home and doesn't want to work from the office, are they obligated to go to the office?
Thank you, Jamin. This becomes a judgment call that the employer has to look at all the facts. I think it's a good opportunity to talk to your employees on the reasons why they don't feel comfortable going back to work, to make sure and to inform your employees of all the steps you're taking to ensure that the workplace is safe. But if they have any suggestions, comments on how to make the workplace safer, listen to them and address their concern. On the other hand, a lot of employees feel that they are more productive at home, and companies should look to see, and a lot of companies are looking to see if their employees are more productive at home. And if that's the case, then maybe COVID changed the way people are working and remote work is possible. I also wanted to address the emergency FMLA. That's very specific to taking care of a child due to COVID reason. So if the employee doesn't want to go back to work and it has nothing to do with taking care of a child, then you can't use the emergency FMLA. Back to you, Jamin.
Great, thank you, Min. Yeah, we've all seen in the news of some of the companies changing their policies for teleworking, and certainly some are like our office, we are staggering back to the office, and other ones are closed through September, others are closed through the end of the year. So it certainly depends on your ability to work from home, the infrastructure of the company, and the IT infrastructure, of course. But if there are no other questions, I'll just say that we're happy to set up a call with all of you to discuss the compliance plans for return to work, employment matters, EIDL or PPP loans, anything of the sort that's kind of new and trending. We've got Sasha's email address there on the PowerPoint. I want to thank all the attendees for joining, and to Verdui, Vikram, Nishita, Brinda, Hooman, Min, Prema, and Sasha, thank you all for your time and for participating. I hope you all stay safe and have a great start to the week.
Thank you.
Thank you, Jamin.
Thank you,
Thank
Jamin.
you.
Thanks, everyone.
Thanks, everyone.